Welcome to this video series on the Making International Law in Korea. We'll begin in this week of videos with a description and explanations of the core principles and practices of international law and discuss the primary sources of international in Korea, like colonization and decolonization, Asia's attitude toward international adjudication, and Korea's approach to law and international law, and state sovereignty, and the impact of the colonialism in international law, and the effect of treaties related to Japan's annexation of Korea. Let me first touch upon the Asia's attitude toward international adjudication and Korea's approach to law and international law. It has been asserted that the Asian countries are not active in international trials compared to their Western counterpart. One can easily discover that such assessment is not inaccurate when looking at practices or cases under international judicial institutions such as the Permanent Court of International Justice and the International Court of Justice, as well as arbitral tribunals. Some cases involving Asian nations are parties under the PCIJ, Permanent Court of International Justice, or the SS Wimbledon case, and the interpretation of the Memorial Convention case, where Japan was a party, and the case Belgium brought against China. Under the ICJ, on the other hand, only a few Asian countries, such as Thailand, Cambodia, Indonesia, Malaysia, and Singapore, were listed as parties, and not many cases involving these countries were documented. Similarly, arbitral tribunals also involve a minute amount of cases involving Asian countries. The number of Asian countries that accept compulsory jurisdiction of the ICJ is very limited, which shows the Asian countries' inactive attitude toward the international tribunals. Asian countries are inactive toward international trials due to the following reasons. The first, there exists a notion of distrust toward international law, which originated and was developed by the European countries. The second, Asian nations also place a distrust on international judicial institutions such as the ICJ. The ICJ not only applies the European-centered international laws that Asian countries do not trust, but also have not produced any judges from the Asian nations except China, India, Japan, Pakistan, and the Philippines. Thirdly, it is also worth noting that a dispute among Asian countries cannot be easily referred to international court, as most disputes are related to issue of territory. Lastly, the jurisprudence of the Asian countries can be pointed out. Generally speaking, Asian countries do not prefer to the adversarial means for dispute resolution, but rather give preference to informal consensus dispute resolution, such as consultation or non-compulsory arbitration. The reasons listed above do not completely explain countries' tendency to avoid international trials. Asian countries have started expressing their voice and interest toward the system of international law, and many Asian countries play an important role in international community. In addition, there are increasing number of cases where Asian countries resolve their dispute through international adjudication, such as the territorial dispute settlement between Malaysia and Indonesia, as well as Malaysia and Singapore. This again shows Asian countries changing attitude toward international adjudication through their increasingly active engagement. How about South Korea? The South Korea's attitude toward international adjudication is no different from that of other Asian countries. Up until now, South Korea never used international adjudication to settle disputes. Therefore, it seems that Korea generally remained very inactive in employing international adjudication as a means of dispute settlement. Recently, however, Korean judges have advanced to international judicial institutions, such as the International Tribunal for the Law of the Sea and the War Crimes Tribunal for former Yugoslavia and International Criminal Court. In a case of International Tribunal for the Law of the Sea, the late Judge Chun-ho Park was appointed from the time of the establishment of the tribunal, while Judge Jin Hyun-bak is currently in service after Judge Park. As per the ICC, International Criminal Court, Judge Song Sang-hyun has been appointed and also served as the president of the court. South Korea has many issues to be settled under international law. Such issues include territorial dispute with neighboring countries, issues of transitional justice, and issues regarding the limitation maritime boundary and fisheries. Considering how this settlement through peaceful means would serve national interests, Korea will be more likely to settle international dispute through international tribunals. Especially since increased respect for the rule of law with Korea state can lead to trust and respect for international law, which can also enable Korean people to regard international adjudication as a means to settle disputes and accept the results thereof. To this end, Korea needs a capacity to confidently and competently operate international law and international adjudication and should meet the premise of strengthening its overall capability in international law to achieve the same aim. Let me first touch upon the positivism in international law. The contemporary international law and its jurisprudence appear to be taking on a more self-reflective attitude in coming to terms with some of the core assumptions that have dominated international law since the age of the European imperialism. One such assumption is that international law is concerned primarily with the action of states, and that those state acts has been and continue to be basis for the content of international law. Part of this historical narrative of international law is that this positivistic approach departs from the earlier notion that international law emanates from natural law that found its source not necessarily from the purposeful action of states, but from obligation that existed beyond the states themselves. Accordingly, what can be found in Article 38 of the Statute of the International Court of Justice, in what law the court will apply to disputes between states, namely treaties and international custom, supports the sense that international law has a strong positive strand. State action in the form of treaty making and the state practice element of the international custom confirms the sense that international law is made by the state themselves and product of the sovereign will. However, it is from that very point of positivism in international law that has been under attack not only from other legal philosophical schools in terms of methodological approaches in deducing the content of international law and explaining why states observe international rules, but it has also come under suspicion from others who question the very content of international law and its checkered history. Let me touch upon the new theory, which is the third world approaches to international law, what we call as a TWER. TWER have pointed to the period of the colonial expansion when colonialism was viewed as a legitimate exercise of state power as to when the contemporary rules of international law took shape. Given the impact of this period on international law, TWER scholars look upon the colonial era with a great deal of skepticism on an international system that serves powerful states, exploits weaker entities, through colonialism, utilizing existing concept of international law to justify their activities. Twer views the colonial period as the critical moment in understanding the proliferation of international law as a transnational phenomenon because the expansive nature of colonial project. By focusing on European colonialism, Twer desired to permit the expansion of the forum in which the history of repression can be reflected and criticized upon international law. One of the Twer's major contributions to the study of international is that it has brought to the light how the practice of the pauper state shaped the content of the contemporary international law. It posits that through an examination of European colonialism, international law today can be better understood if seen in light of the European states and their historical encounter with what was then the uncivilized world. This can be seen in how the present rules that govern the disposition of international disputes that deal with fundamental concepts of state sovereignty, such as territorial integrity, along with the conspiracy failure during the colonial period to recognize self-determination as a legitimate legal principle. By relying on the legal positivism as its philosophical base, the international lawyers of that time have to lay the groundwork for an approach to international law that reflected European experience of the statecraft and international relations. As one Twer scholar put it, the sovereign doctrine and sovereignty doctrine is understood as a stable and comprehensive set of ideas that was formulated in Europe and that extended inexorably and imperiously with empire into the darkest Africa and into trouble the Orient and the far reaches of the Pacific, acquiring control over these territories and the peoples and transforming them into European possessions. As such, it is in the sense that there is a felt unfairness because of the absence of any meaningful contribution from other non-European states in the development of international law and skewed international law in the favor of hegemonic states. The positivism that marked this earlier generation of international law that conveniently justified the colonial activities of European states continued to make its mark on the very principle that was supposed to limit the injustice caused by international law's non-recognition of nations as states, which is the self-determination. With the end of the World War II and the advent of the United Nations, the former colonial holdings of imperial powers has the opportunity to participate in the international system as legally equal players. The principle of self-determination enshrined in the UN Charter, International Covenant on Civil Political Rights, and International Covenant on Economic, Social, Cultural Rights gave former colonies the right to statehood. However, there are clear restrictions in the application of self-determination principle. States that were both colonizers and former colonies, which had become newly independent, sought to place definite limits on the application of self-determination so as to be not too destabilizing. European colonial states naturally desired to see the principle only applicable to the area outside of Europe informally governed, while the newly independent state in Africa desired to maintain the principle of the uti possidetis and keep the pre-existing colonial borders with the hope of securing colonial stabilities. Since states, especially those that were newly conceived, were concerned for survival, international rules that promote their interest in establishing stability regarding their territorial boundaries made sense, despite the emergency of the principle of self-determination, which seemed to defy traditional norms. Thus, the positivism in international law helped to create the conditions for an instrumentalism in its use so as to maintain the status quo ante. It has continued to do so because it has colored a basic principle of international law, such as state sovereignty.